Hello. In our last segment, we heard about debt lawsuits and how the Bromberg Law Office protects consumers within these lawsuits. Now we're going to talk a little bit about debt collector abuse or harassment and some of the ways that attorneys protect consumers in these ways. Brian, can you tell us a little bit about what you see related to debt collector abuse and harassment?
I've seen the gamut. I've seen, and I see, people getting threatened with criminal prosecution. It's not a crime to take out a credit card and fall behind on it. It's not a crime to have an accident or have a medical condition and sometimes you just can't pay the bills. It happens. There's nothing criminal about it in 99% of the cases. Nevertheless, I've heard debt collectors on the telephone threatening people with criminal action, accusing them of felonies. I've seen it. It's terrible. That's sort of the most egregious kind of thing you see is outright unlawful threats, use of racist language, use of abusive language. Those are sort of the most extreme versions that you come across, and you will hear those on recordings occasionally. Other things you come across is attempting to collect fees that are not due. Things like attempting to collect, 42% interest on a tuition bill. I mean, these are the kinds of things that are frequently not allowed. Attempting to collect 15% collection fees when there's no right under the contract to collect collection fees. All sorts of abusive attempts and things that are really over the top, things that people are just not legally allowed to do. If a company is not legally allowed to collect attorney's fees or collection fees and they attempt to collect them, that's a violation. Other things, I've had situations where landlord's attorneys will dismiss a case with prejudice, which means they can't pursue the debt anymore. And then 6 months later, they'll suddenly start suing again on the exact same debt that they just dismissed 6 months earlier. That's illegal. You can't pursue people in that manner. That's just not appropriate. Other things, unless you have a judgment against someone, you can't contact their employer for almost any reason. You can't speak with their neighbors. You can't speak with most of their relatives. Frequently, you can speak with a spouse, but you can't speak with the kids. You can't speak with the grandparents or the parents, even, for that matter.
And isn't that a frequent source of harassment? Because naturally, if people have a debt, they might want to keep it secret. So the debt collectors are threatening to essentially expose them or tell their friends or make their private debt public. And that's all part of the prohibited activities that you just cannot do.
Yes. I mean, the client may not, the consumer may not even owe the debt.
Sure.
Okay? You can't shame someone into paying something that they may or may not owe. You can't contact the employer and make their lives hell. You can't contact the relatives or friends. Frequently, they'll contact a parent. The parent will freak out. The parent will be elderly and go, "Oh my God, why do you owe this? How can you do that?" You can't do that to people. You can't publicly humiliate and embarrass them as a means to collect the debt. You want to collect the debt, take someone to court, litigate it, argue on an even playing field. Don't publicly smear their name to collect something they may or may not owe.
And so what forms of relief are there for individuals that might have been victims of debt collector harassment?
Well, in New York, the strongest rights you have are frequently under the Federal Fair Debt Collection Practices Act, which is sometimes you have rights under the State Deceptive Acts and Practices Law, but it's really the Federal Fair Debt Collection Practices Act that gives you the strongest remedies. You can take a person to court and you can try and get up to $1,000 in what's called statutory damages, plus any actual damages you suffered. Plus, if you are the prevailing party in the lawsuit, the other side will have to pay your attorney's fees and costs. So this is the kind of thing you can do. You have remedies, you have rights, you have things that you can do. I've been litigating Fair Debt Collection Practices Act cases now for almost 20 years. Some of the leading cases in New York are cases that my office has been responsible for making the law on. So you want someone experienced to pursue these cases. You don't just want to, go into Google and type up whatever company. You want someone with experience.
And how does someone ultimately prove that they have been harassed? How do you work with them? How do you build the case, so to speak?
Well, frequently it's nice if they actually have a recording, but sometimes you can't take recordings.
Sure.
Sometimes because there could be legal issues. Ideally, you have some kind of evidence of what happened. But if something terrible has been said, we can sue over it, and sometimes the credit reporting, the debt collection agencies will actually have recordings and records of the harassing actions that they've taken. Another way is you come in with all the correspondence, you come in with all the documentation. If the debt collector's spoken with a neighbor or with your employer, put us in touch with that person. Let us talk with them. Let us evaluate their statements. So even if you don't have recordings, or even if it might not, even if you couldn't make recordings because of various complications, a case can still be proven by talking with your neighbor, by talking with your employer, by talking with the friend who received the communication, and through that means we can evaluate their testimony and bring a lawsuit. And then we can take depositions of the debt collector's employees and find out what really went on. And we can also look at the collection notes and see if there's anything recorded there. And there'll also be records frequently of who they called, who they spoke with. So we can get into all this once we're in the litigation.
Yeah. To sort of just put a fine point on this, if you are speaking to someone that believes they have been a victim of debt collector harassment, what's the 30-second answer that you give to them? What should be in the forefront of their mind?
Take every single document you have related to the alleged debt, related to the debt collection activities, any voicemail messages you have, any records of any phone calls made to your cell phone or your home phone, everything. Take it all together, bring it into me. Pick up the phone, make an appointment, bring it into me. And we'll sit down, we'll listen to it together, we'll go over your options, we'll talk about what happened, we'll see whether there's anything that can be done there. Don't erase anything, don't throw anything away. Keep every letter that you get in pristine shape. Also, within the first 30 days of the first written communication you receive from a debt collector, you should absolutely send out a letter, certified return receipt, saying, I dispute this debt. Okay, that requires them to then go verify the debt. You absolutely want to get that out. You want to get a record of your dispute out there, and you want to force them to verify the debt.
Because in addition to you having your own personal records, the debt collector has to be able to substantiate the validity of the debt that they're collecting.
Yes. The debt collector, within that 30-day period, if you dispute the debt, they have to come forward and send you some kind of verification or validation of the debt. Unfortunately, they don't have to provide you with much, but at the very least, you want to force them to take that step. But the biggest thing is, anything comes in from a debt collector, you feel that you've been the victim of any abuse, or you're not even sure whether you've been the victim of abuse, pick up the phone, call an experienced lawyer. It doesn't have to be me. It can be someone. Just fight for your rights. Don't just sit there and take it.
Okay, thank you. I think that's very helpful information.
Hi, I'm Brian Bromberg of the Bromberg Law Office, and I've been fighting for consumers for almost 20 years. If you are being sued by a credit card company, bank, credit union, or debt buyer, it is vitally important that you respond to the lawsuit in the correct manner and in the short time frame allowed by law. Failing to do so can result in a default judgment against you. We are extremely well versed in all aspects of debt defense law, and we will take the time to carefully explain the entire process, your rights, and your options. Contact us today to set up a free consultation.